For judgment, item number 1, STR is 75 of 2003 and batch of matters.
You've answered the question in favor of the department and against the assessment. The revision petitions are dismissed.
For mentioning Mr. Ranjan Kumar Rao. Sorry, Mr. D.K. Mansa.
Yes. I may pardon to mention there are two writ matters, OEA Act related, old matters, OEA Act related. It can be posted for hearing. I pray because status order is there, government land status order is there. I have given the memo, it may be listed in weekly list.
All right. All right. To be included in the weekly list. All right. All right.
Mr. Rupesh Kumar Kanungo.
You are permitted, Lordship. Lordship, pursuant to direction of Lordship, matter is listed before the Honorable Court number 3, Lordship, comprising of Justice B.R. Sterling and the Honorable Justice S.K. Mishra. They have directed that matter may kindly be listed any other bench where Mr. Mishra will not be a member. We ask the DR to place it. I have already. All right.
Mr.
Six 2022, your lordship were pleased enough to issue notice and as an interim measure directed the petitioner to pay from 7/11/2017 to June 2022. Now, my lords, what happened? On receipt of the judgment order of this honorable court, the superintending engineer raised a bill which included 6 times penalty and compound interest at the rate of 2%, which comes to rupees 12 crore some odd. And I represented, that is, in this case, at Annexer A, page 5 matters, that this is not imposable and 1 crore 66 lakhs I am ready to pay. Then, my lords, this was sent to the Annexer C at page 7 to the chief engineer. That lordship will kindly see that letter Annexer C at page 7. In inviting a reference to the above letter, it is to intimate that again the above industry has submitted another letter dated 3/8/2022, wherein the industry has requested to pay only the principal amount. Then where is the question of unauthorized?
Let him serve a copy, I will get instructions.
I have already served a copy,
No,
madam.
that is not there in the file.
I have already served a copy.
One more copy, sir. Notice, Mr. Mohanty accepts notice. One more copy of the application be served on him today itself.
Balance.
23rd.
Subject to the petitioner paying 1
crore 66 lakhs, madam. I will pay within a week.
All right.
Within a week.
Rupees 166,49,256 within a week from today. The demand for compound interest and penalty shall remain stayed by the next date. The list on
28th September is already set.
28th September, the date order. All right.
Much obliged, madam.
Supplementary list item number 3.
My lord, in this case.
Yeah.
He has already been released on bail, but so far that stigma of conviction is concerned, if your lordship permit, I can take instruction.
No. The 2003 matter, sir.
Yes, my lord, 3 matters, my lord, that is referred.
I am
probably-
criminal record 463 of 2005.
Sir, your matter is not called out yet, Mr. Mishra.
I'm sorry.
The supplemental list item number 3, CRLMC 2817 of 2003. 1 week after.
Not, we can't adjourn it, sir.
My lord,
Let's
there
start
are-
it with him.
these matters are all connected matters. They have come up today for the first time. Can
First
your lordship give us a week's time so that we can ascertain?
Sir, this is the 2003 matter, so I can pass it over, I won't adjourn it, sir.
Lords, we understand, my lords, but because they are old matters, we are not conversant as to what is the present position.
So whatever, this is really part of the old list we have released already, sir. It's not suddenly coming up.
And my incident is 23 years back, my lord.
This is incidents of 18 years, whether the petitioners are alive or not, we are not aware.
So we
Yes,
can
my-
pass it over, you find out, sir. We can pass it over. Pass over.
Your old matter.
Next week,
Whatever,
next-
it's all right, sir. We'll pass it over.
next week, my lord, because
It
it
is the last item in your lordship's list, I believe.
Oh, this is the last item, okay.
Next Friday, your lordship may call it and let it.
next Friday.
Report be called from the local police
So
station.
it's a holiday, sir.
Petitioners are there.
Any working day,
Any
my lord?
other day, my lords. may call.
Any other day?
Why is it before DB?
It has become on the basis of a reference, my lords.
We
Honorable
can
single
check it. What
judge.
is it? Let's see the order of reference. Let's see
Yes,
that.
we have not gone through that order also.
We'll go through it, sir. Right now we'll go through it.
Any date, your lordship, I will pray, my lord, humbly pray, my lord.
Let
Any
me just see what the matter is, sir. Let me familiarize myself.
matter, my lord, whether after the submission of a final form in respect of some of the accused persons.
Interval page 6. All right. On the judgment.
Whether the court can take cognizance.
So in that case, charge sheet was filed as 3, and regarding other accused persons, charge sheet was not filed. So a question was raised before the Honorable Magistrate whether Magistrate can take cognizance so far the persons who have not been charged sheeted. That was the question.
And
I'm reading the exact that part.
and there are decisions from both the sides, my lord. We must find out the latest decision.
The magistrate can file the cognizance. Magistrate can apply his own mind over the charge sheet, and magistrate can take cognizance. That's the law.
No, but if it is a tribal court of sessions, then only the 319 is applicable. Not the magistrate cannot differ from the charge sheet and take cognizance.
We can't
One
distinguish.
adjournment, my lords, will not hurt me, lords.
No, we can't distinguish a Supreme Court judgment, sir. A Supreme Court judgment is binding.
Supreme Court judgment, my lord. I have also Supreme Court judgment. We will have to examine which is the latest, my lord.
And all the judgments have been referred.
That is
My lord, that is why Dr. S.
question with Supreme Court judgments which are contradictory.
Since it was contradictory, therefore the matter is referred.
Maybe we can address your lordship.
Yes. Any that your lordship fix a date, my lord, we all will address your lordship.
There is one judgment of the Supreme Court in Kishan Singh, another judgment in, I believe, Ranjit something. So that has been referred, my lords, therefore.
Kishore Singh also
Find out the
another.
latest position and will be in a position to assist your lordship better.
Kishore Singh is also another judgment by Honorable Justice G.B. Patnaik and by Honorable Justice Sethi, my lord.
Here, what is the offense under?
Lords,
this
in
case,
my
what is
case, it is 302.
Yes.
My case also 304B, my lord. Trial by Court of Sessions. So the Sessions judge only can exercise the power under section 319 at the time of evidence, not the magistrate. Magistrate cannot take it. Therefore, my lord, this was referred.
Taking cognizance to recognize what offences are being made out. It is not being taken with the accused. So the magistrate has the power.
But let us be in a position.
Whatever has been filed by the police, the magistrate has to apply the mind over the same. And then we can take cognizance.
For Mr. Katia, it is very easy to make such
Two
submission.
judgments of the Supreme Court.
Yes,
That's what-
yes.
Yes, the matter is.
One judgment is SWIL, the other is Rajendra Prasad.
Yes. And
SWIL is a magistrate's tribal case.
Page 9.
yes.
One.
My lord, latest judgment on the point is 2012, volume 3, SCC, page 383, my lord. Gile
What
Singh
does it
versus
say?
State of
What
UP.
does it say?
My lord, that says, my lord, in the case of this nature, only courts open is under section 319.
Yes.
Court cannot take cognizance, my lord. My lord, may see 2012 volume 2 SCC criminal 175 or my lord 2012 volume 3 SCC 383.
The same view also in 2000 volume 19 OCR.
Yes, yes, my lord. That in that view that has been taken note.
That is
Should we call it any day, my lord, so that we'll be in a position?
We'll familiarize ourselves with what the issue is. 1 minute.
The issue is simple, my lords. The issue is whether a magistrate, in respect of accused persons against whom charge sheet has not been submitted, or they are shown as not submitted in the charge sheet, whether he is competent to add them as accused persons at the stage of cognizance. This is the question, my lord. There are divergent judgments of this court, my lords, on the field, my lords. And there are also divergent judgments of the apex court. If your lordship gives us a few days' time, we shall assist your lordship effectively. That's what we are saying.
Yes, yes. Mr. Dale, what was the page number? 2012?
My lord, that is 2012 volume 3 SCC 383.
383.
Gile Singh versus State of UP and another.
Ah, all right.
So far as I recollect, my lords, I believe there are later judgments also of the apex court. They may be in our favor, may not be.
there are latest judgments.
Another
So this-
decision, my lord.
This judgment, Mr. Pata, this judgment is also in favor of the petitioner.
Yeah, it may be,
Yeah.
but there may be some other judgments. which
No,
may
no,
not be in
I
our
have
favor.
verified. I have got a judgment of High Court of in High Court of Punjab and Haryana. That is the latest one. That is January 29, 2019, my lord.
Yes.
Devender and others versus Dharampal and another. That is, they have taken note of this. They have taken note of this Gile Singh, my lord.
Yeah.
They have also taken note of this Gile Singh.
So only the sessions court could thereafter take cognizance.
Yes, ma'am.
Right.
The same view, my lord, in the case of my lord Kesari Singh, reported in 2000, volume 19 OCR, Supreme Court, page 647, my lord. If it tribal by court of sessions, only the session judge can exercise the power under section 390, my lord.
So this judgment, Mr. Katkia,
Well,
follows that Raj Kishore Prasad, Ranjit Singh, Kishori Singh, that line.
Yes.
Let it be taken up, my lord, next week, so that we all will assist, my lord, for to answer this reference, my lord.
concern with the issue of the sessions court can add into the sessions court.
On Tuesday, it can be taken up.
And all these cases, my lord, tribal by court of sessions.
If Mr. Dhoda has made a study, my lord, I think the judgment in our favor should be.
No, I have given a note also earlier, appearing, though I have appeared on behalf of the informant, I have given a note. I had given a note long back. Well, in criminal division number 217 of 2006, I have given a written note of submission during that period. And latest judgment is 2012 ballot.
So, Mr. Dale, your
My case is ballot criminal division number 217 of 2006.
right.
I'm appearing for the informant. But ballot, the law is, I have to support ballot the law.
Correct. So you're actually supporting the other side.
So,
Ballot, I had given the note, but I was verifying my file. It was given long back, ballot.
I have to verify the current position of law.
All right. Mr. The court's attention has been drawn to the judgment in Gile Singh, versus State of Uttar Pradesh 2012 3 SEC 383, where the question whether it is open to a magistrate to issue summons to a person as an accused after committal of the case to the Sessions Court has been answered in the negative by following the decisions in Ranjit Singh versus State of Punjab 1998 7 SEC 149, Kishori Singh versus State of Bihar 2004 13 SEC 11, and Rajkishore Prasad versus State of Bihar 1996 4 SEC 495. Paragraph. Yeah, on the basis of a private company. Right. Mr. Katkia states that he needs to both Mr. Katkia, learned AGA, as well as the learned senior counsel for the petitioners seek time for addressing the court further on the issue involved.
But I am also praying for time. That would be.
Yes, the entire.
I've said learned senior counsel or church. Okay, all learned.
Mr. Ponda is also a senior counsel.
I can't take that privilege, or I can't ask for that privilege.
I am appearing for the informant.
Thank you, Mr. Dola.
2nd September.
I am appearing, my lord, in criminal division number 217 of 2006 and criminal division number 446 of 2006 for the informant, my lord.
All right.
Specialist for hearing item number 1, CRA 65 of 2000.
He has already been prematurely released.
He has
been released prematurely.
Yes.
We have that information from the prison.
The premature release.
The prison authority has informed the court that the appellant has been prematurely released. And the standard order, we have already got a standard order. It's disposed of with liberty to the appellant to revive the appeal in case he desires the appeal to be heard on merits. All right.
Specialist item number 2.
Same order.
No,
Sorry.
my lord, here in this case, my lord, criminal appeal number 291 of 2005. My lord, this premature release, and Chabi Patnaik, criminal appeal number 124 of 2005. Chabi Patnaik is dead, but another accused has been left, my lord.
Sir, in 291, there is only one appellant.
My lord, 291 is one appellant. And criminal appeal number 124 of 2005, my lord, 2 appellants. Out of they, my lord, one Chabi Patnaik, death is last in the year 2008.
All right.
Another appellant is Abhimanyu Patnaik. He is there, my lord. So
he's still in prison.
Still alive, my lord. Yes.
All right. So 291 will dispose of.
My lord.
And in 124, 291 same order. In 124, you say Mr. D.P. Dalal and a senior counsel appearing for the appellants informs the court that appellant number 1 has already expired, and therefore the appeal as far as he is concerned has already abated. As far as appellant number 2 is concerned, the appeal is still. He's on bail, is it?
My lord.
He's still on bail. Set down this appeal for hearing on a Thursday, which was Thursday. Yeah, 25th. 25th August.
Specialist item note 3.
But I think the order passed by your lordship in item number 1 will suffice in this case also.
Correct. Same order. Right, sir.
Problem.
Specialist item number 4.
Item number 4, though the appellant released prematurely, but it is a case, my lord, where the appellant taken a plea of insanity, my lord. That has not been considered since the time of investigation, my lord. Your lordship may call it for hearing.
The hearing right now, sir.
Yes, sir.
You want it to still be heard, and although he's released, you want it to still be heard.
My lord, the conviction will be go, my lord, and
Suppose the conviction is affirmed, you don't mind.
my lord, it is a case.
No, if you're confident, there's no difficulty. You should not create problems for your client.
For that reason, I have prepared a lot, my lord. For that reason, I am praying for the plea of insanity has not been taken.
No. So we will decide it, sir. There's no problem. We'll hear you and decide it. You should make up your mind whether you're creating problems for your client or you're making it easy for him.
It's like.
Which is why we're adding a line that if the appellant so desires that he still wants the appeal to be heard on merits, we are prepared to hear it. But let him take the call.
Yes, Lord.
So same order.
Specialist item number 5.
Your lordship disposed of.
Yes, with liberty to the appellant to revive the appeal if he wants the appeal to be heard on merits. Or
Item number 5.
yeah, same order.
Specialist item number 6.
Same order.
Specialist item number 7.
7, I am there. Your lordship has the same order.
Yes, same order, sir. Same order.
Specialist.
1 minute. There are 2 appellants here.
My lord, there are 2 premature release reports. Flag
I
A
see.
and Flag H.
Oh, church. All right. Same order.
My appearance may be this way.
Yes, sir. Of course.
Item number 8.
Same order.
Specialist item number 9.
Same order.
Specialist item number 10.
Same order.
Specialist item number 11.
Same order.
Specialist item number 12.
Your Lordship, may kindly call up this matter next week as the conducting counsel is out of station, Your Lordship.
No. This man has been prematurely released. So we're not.
Your Lordship, then may dispose this matter with liberty, Your Lordship.
That's right. Same order. That's what.
Specialist item number 13.
Well, this is also a premature release, but only my appearance may be recorded in the same order, my lord.
Same order. All right.
My appearance may be recorded.
Yes.
Specialist item 14.
Same order.
Specialist item number 15.
Same order.
Specialist item number 16.
Same order.
Specialist item number 17.
Same order.
Specialist item number 18.
Same order.
Specialist item number 19.
Same order. There are 3 appellants here. Just see that.
11-1.
And take the paper book.
Please.
Registered an appeal. So can you just check up this? One of them has been released. There are 3 appellants. This has been sent. Jail appeal has been sent the home. Only one person. Probably advocate. You see, it is seen that the present appeal sent from jail was by 2 appellants, that is Gangadhar Naik and Shikhara Naik. As far as Gangadhar Naik is concerned, there is a report received from the prison authority about his premature release. Consequently, the appeal will continue as far as the co-appellant Shikhara Naik is concerned. A report we called from the jail authority about Shikhara Naik for the next date, including the total number of years spent by him in custody. List on which was that date? 26th, Thursday, August 25th or 25th August.
Specialist item number 20.
You see, as far as appellant number 1 is concerned, the cost title, you see, the order will be that it's disposed of at liberty to him to revive. The appeal will continue as far as appellant number 2 is concerned, and the cost title be corrected as Shikhara Naik versus state.
Specialist item number 20.
There's 1 appellant in this case.
1 appellant is it? All right, same order.
Specialist item 21.
Only 1 appellant. All right, same order.
Specialist item 22.
I don't have the file in this case, but
Just shows the file.
Yes, so 1 appellant, Suna Munda.
Only 1 appellant, is it?
Yes, Master.
All right, same order.
Specialist item 23.
Item 23, appellant is prematurely released.
Correct. Only 1 appellant, right?
Only 1 appellant.
All right, same order.
Specialist item 24.
Yeah, only 1 appellant.
1 appellant.
Right, same order.
Specialist item 25.
Same order.
Specialist item 26,
One appellant. Right, same order.
specialist item 27,
One appellant. All right. Same order.
specialist item 28,
28, your lordship, on behalf of Ms. Panda, your lordship, kindly taken up 1 week after.
No. He's been prematurely released, sir.
Yes,
No
sure.
difficulty. Only one appellant. Same order.
specialist item 29,
Same order.
specialist item 30,
Only one matter. One appellant. All right. Same order.
specialist item 31,
Single appellant. All right. Same order.
specialist item 32,
Here there are two appellants. Just show us the paper.
There's 2 appellants.
In the present case, there are two appellants. Appellant number 2 has been prematurely released. So the appeal is disposed of as far as he is concerned. As far as appellant number 1 is concerned, the jail authorities are directed to submit a report on the current status of the said appellant. List on 26th, 25th, all right.
specialist item number 33,
There's 1 appellant.
One appellant, same order.
specialist item 34,
The cost title should be changed. That matter. To Sulochana, whatever. Correct.
item 34,
3 appellants, Lord, in this case.
But in criminal appeal number 41 of 2007, the appellant is on bail.
So you say in JCRLA 6 of 2009, the appellant has been released prematurely. So same order. In the other 2 appeals, 41 and 7 of 2009, you say list for hearing on, give a longer date. 22nd September.
I
Yes,
think in jail criminal appeal 7 of 2009.
Yes,
jail
Lord. The premature release is there.
Premature release is there.
JCRL 7 by 2009. 7 by odd item.
So 7 also same order. Only 41 you say list on 22nd September.
specialist item 35,
There's 1
Sole
appellant.
appellant. Yeah, one appellant. Same order.
specialist item 36,
I think only one appellant.
1 appellant.
Same order.
specialist item 37,
So just one appellant.
One appellant. Yeah, same order.
specialist item 38,
Just give me the paper book. Only one appellant. All right. Same order.
Supplementary stress admission item number 1, ARBP 43 of 2022.
Yes, my lord. In this case, it's a fresh admission. My lord, the arbitration clause in page 27 euros. Page 27 is the arbitration clause.
I think it is a CPW matter and copy didn't serve. So let them serve the copy.
All right. Notice Mr. Party accepts notice. A copy be served on him. Reply and if any be filed within 4 weeks, rejoined for the next day. List on 23rd September.
Supplementary list item number 2.
May I please, Your Lordship. Lordship, on last occasion, Your Lordship was directed to surrender, but we have no instruction till the date.
Counsel for petitioner states he has no instructions, dismissed for not possible.
Because he has not been arrested despite the effort of the police by now. This is my instruction.
Very sad, sir, really.
Yes, I'll give the copy of the instruction. That's not.
Yeah, the surrender certificate nevertheless be filed as and when the petitioner is apprehended. Right.
That's all yours.
Supplementary list item number 3.
Item 3, my lords, I pray for a short password on behalf of Mr. Milan Kanan.
All right.
Great.
Supplementary list item number 4.
Item 4, my lord, Your Lordship, remember that larger, the NN Global mercantile case has been referred to the larger bench regarding the payment of the stamp duties and the arbitration agreement. That as I take the help of the Honorable Supreme Court has not yet been decided that matter, or also the larger bench has been confirmed. But the fact remains, my lord, Your Lordship, remember that in case the Supreme Court says all the arbitration appointment matter is to be decided within 6 months. On the last occasion, my lord has been pleased to adjourn the matter, awaiting the result of the Honorable Supreme Court. If the question has been raised therein.
All right. It is stated the matter is still pending with the larger bench of the Supreme Court. (23rd September).
Pardon?
23rd September, sir.
Obligement.
Supplementary list item number 5.
My lord, item number 5, I am for the petitioner. My lord, brief fact of the case is that the item number 5, Your Lordship, kindly pass over, Your Lordship.
All right. Pass of flex.
Supplementary list item number 6.
Lord 6, I am appearing for opposite party, my lords. There was a conflict.
I am appearing for the petition.
Carry on, sir.
My lord, I pray for a passover.
All right, passover.
Supplementary list item number 7.
I am appearing for the opposite party, my lord. The counter affidavit is ready and I am filing in course of the day.
All right. Counsel, the opposite party states that he'll be filing counter affidavit during the course of the day. Rejoined for the next date.
Appearance of London ASG and myself will be recorded.
23rd September.
Supplementary list item number 8.
But in the meantime, they are proceeding with the matter, notwithstanding the stay order in item number.
File a contempt or something, sir. Whatever. Yes.
Item number 8.
My please, Your Lordship. Item number 8, Your Lordship, pursuant to order, the tracking report is, my lord, delivery is confirmed, my lord.
Right. You say the despite service of notice, none appears for the opposite party. What's your claim, sir?
Lord, there is a claim and counter claim near about 25 lakhs, Your Lordship.
25 lakhs?
25 lakhs, Your Lordship.
All right.
Any advocate, my lord?
Mr. Prashant Kumar Jena.
No, I don't know. I've seen some experience in arbitration. Any Mr. Palit or Mrs. Rao, any advocate.
Correct. Mr. Subir Palit, senior counsel, is appointed the sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration set.
Supplementary list item number 9.
Your Lordship, I am entering appearance on behalf of OP 1 and 2, and I request Your Lordship to kindly grant us some 4 weeks of time to file a counter on this matter.
Counsel appearing for the opposite parties 1 and 2 seeks and is granted.
I'm appearing on behalf of 3, 4, and 5, Your Lordship.
All right. And he appears on behalf of 3, 4, and 5. Mr. Anshuman Rai. Reply be filed within 4 weeks, rejoined of the next date.
That will nice.
30th September, 30 September.
Supplementary list item number 10.
Item number 10 minutes. I have entered appearance for Sol of P. Need some time to file counter.
All right. Opposite party, counsel for the opposite party seeks and is granted 4 weeks time to file reply, joined up with the next date. 30th September, 30 September.
Supplementary list item number 11.
Compromise petition.
Item number 11, in fact, my lord,
There's a compromise petition.
it's a compromise petition, my lord. Parties are compromised and the parties are brothers, my lord. My lord, there is some family dispute for which,
a confirming judgment.
But if the
but in the meantime, there has been compromise between the parties.
who is Mr. Tripathi?
My lord.
So we record the compromise
My lord.
and quash the proceedings.
My lord.
Or
Plus, here is against the confirming judgment. The London trial court has convicted, subsequently in appeal, that order has been confirmed. Now they have come up in revision. At this stage, whether it can be quashed or not. The question was if Nagaland can show any judgment to that extent. Conviction is 326.
324, 326.
Yes.
326 is not compoundable, I think.
Yes.
Do you have a judgment?
Yes, my lord, I have a judgment, but the difficulty is, my lord, Mr. Kali Prasad Mishra was supposed to appear in this case, my lord, for the petitioners. He is not there probably.
Mr. Katke states that although there may be a compromise between the parties, in the present case, there was a conviction by the trial court which is affirmed by the appellate court.
Yes.
For the offences punishable under section 324 and 326 IPC. Counsel appealing for the petitioner seeks an adjournment. List on 30th September.
Supplementary list passed door matter item number 3.
Malot, item 3.
Yes.
Malot, actually, Mr. Samantra has engaged me in this matter. He's
Yes.
coming from Bhubaneswar. I don't know, Malot, there is some problem. He's stuck up somewhere.
All right. At the request of Mr. Milan Kanugo, learned senior counsel appearing for the petitioner. This on 30th September.
Deeply obliged. Deep.
Passed door matter item number 5.
No time, my lord, I am for the petition.
There was a passover sought on behalf of the opposite side. Pleadings are complete, correct?
Yes.
However, none appears for the opposite party despite a passover.
Item 5.
Yes. Yes.
My senior is on his legs, is coming. All right, some other days. List on 30th.
30th, my lord?
September. Supplementary list passed door matter item number 6.
Lord, seeks I pray, my lords, 2 weeks time to file our objection. My lords. All right, counsel the opposite party seeks and is granted 2 weeks for time to file a reply. Rejoined up for the next date, 30th September. My lords.
Okay. This list is open.
Which one now?
Specialist.
Specialist, item number 1, CRLMC 1627 of 2015.
None appears dismissal of obstruction. Intermodus vacated.
My lord, I am the virtual, my lord.
Yes, please.
My lord, on this matter, may no instruction, my lord. May I give a liberty to raise the point in tribunal, my lord. Trial court, my lord. Sorry, my lord.
All right. Permitting the petitioner to raise all the please raise in present petition at the appropriate station. The petition is disposed. So,
Obliged, my lord.
Specialist, item number 2.
none appears dismissal of obstruction.
4042.
Yeah.
Lordship. Lordship, offences under section 498A, Lordship. And the petitioners are the sister-in-law and father-in-law and mother-in-law. Lordship, there is no in FIR, there is no allegation against them, Lordship.
But we can dispose it of in the absence of the complainant. So we'll permit you to raise all the pleas, permitting the petitioner to raise all the pleas raised to present petition at the appropriate stage. The petition is disposed of. All right.
Specialist, item number 3.
My lords, in this matter, I've been engaged, my lords, but unfortunately, my name does not appear. I was engaged just last week. The file hasn't come. Lordships may keep it any other
Okay.
day.
At the request of Mr. Kanungu, done senior counsel, list on 30th September.
Deeply obliged.
Specialist, item number 4.
None appears dismissal of obstruction.
Specialist, item number 5.
None appears dismissal of obstruction.
Specialist, item number 6.
It has been rendered infructuous, your lords, by item 6.
Infructuous disposed of. Interim orders.
Specialist, item 7.
May I please, Your Lordship? The present petitioner is asserting the very initiation of the proceeding, that is 493 along with other offences. Your Lordship may can see the affidavit filed by the opposite part number 2 is the complainant. She has admitted that there is a marriage. And for that reason, she had initiated proceeding under the 125 of also DV proceeding for claiming maintenance. If she has claiming maintenance, stating therein that I am the wife, I am the husband, there is a question of 493 by now.
Anyway.
Deceitfully inducing a person, and she has admitted in her affidavit that she is the legal married wife of the present petitioner.
Has you been served?
Paragraph 9 also in each and every paragraph, my lord, she had admitted that the copy has been served to me. The affidavit which has been filed on 16/4/2018.
The notice has not gone in this petition yet. No notice has gone in this petition yet. For 7 years now, no notice. So we permit you to raise all the pleas at the
Well, on 26/5/2017, notice has been issued. 26/5/2017.
The order is not with us. There's no such order. Just ask, show it to him, please.
Encourage ಮಾಡಿ.
Are you appearing in the right matter? You're appearing in the wrong matter.
No, this is my matter.
Then,
but another matter is
permitting the petitioner to raise all the pleas raised in the present petition, the appropriate state petition is disposed of. All right.
Specialist, item number 8.
May it please, my lord, someone VC, Lordship.
Yes.
Lordship, I have received a brief today morning. We need to contact the petitioners for certain information, your Lordship.
No, it's okay. We permit you to raise all the pleas at the appropriate stage.
Lordship, may grant a week's time, I mean.
Yeah. Permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. Petition is disposed. All right.
Item number 9.
None appears dismissal of obstruction.
Specialist, item number 10.
The memo is taken on record. No instructions. Dismisses withdrawn. Interim orders repeated.
Specialist, item number 11.
None appears dismissal of obstruction. Interim orders vacated.
Specialist, item number 12.
No instruction, Lordship.
No instructions, dismissal not possible.
Specialist item number 13.
None appears, dismissal not possible.
Specialist item number 14.
None appears, dismissal not possible.
Specialist item 15.
None appears, dismissal not possible.
Item number 16.
May I please, Your Honor?
Yes.
In this case, my lord, quashing of a criminal proceeding, my lord, that is initiated by the stepmother of the petitioner and number one, and a mother-in-law of petitioner 2, my lord. Accordingly, in this case, my lord, there is a case and a counter case, my lord. What happened in this case, my lord? Offense cognizance taken and also charge frame under section 452, 341, 223, 294, 354, 506, 34 IPS, my lord. My sole submission before received, my lord, no prima facie is at all made out against the petitioner as because 452 criminal trespass, house trespass, my lord. They are belongs to one family, my lord. Question of house trespass does not arise. Again, my lord, wrongful restraint, my lord, that is also not there as because they are residing in a one family, my lord. Stepmother laws information. 323, there is no such injury, and 294, my lord, in the private place, my lord, in the house, my lord, there is the allegation that the abuse petition, my lord. Question of 294 doesn't arise as because in the house, my lord, not in the public place. And 350, my lord, stepmother, my lord, laws information 350 cognizance taken and charge frame against a lady, my lord, petitioner 2, my lord. That is not there. 506 also not there, my lord. No prima facie is at all made out against the case counter case. In order to escape from counter case, this has lodged the enforcement against the petitioners, my lord.
AD card has not come back from opposite party.
My lord,
No.
notice served, my lord. But she did not choose to contest in this case. For that reason, nobody appeared, my lord.
No.
And in the counter case, my lord, they had also filed another case. In that case, we have entered appearance.
Which
And
is that
sir,
case? Which is that case?
My lord, that case, my lord, last week it was listed, but we have already entered criminal case 4913. Both cases.
No, we'll see what happened to that.
4913 to Sunday 14, my lord.
We'll just check what's happened. List along with 4913 of
2014, my lord.
2014 on 2nd September.
My lord, oblige.
Specialist item number 17.
None appears, dismissal not possible.
Specialist item number 18.
None appears, dismissal not possible.
Specialist item number 19.
Memo taken under court. Withdrawn, dismisses withdrawn.
Specialist item number 20.
20 May plus. I mean virtual volumetric. The settlement has been between the parties, which is a compromise affidavit has been placed between the both parties, which is annexed in Annexure 6, my lordship. Case arising out of civil dispute between the parties.
But this is not supported by an affidavit, sir. Just a plain paper compromise. And the other side is not here. You presented before the trial court, permitting the petitioner to present the compromise petition before the trial court in accordance with law. The petition is disposed of.
Specialist item 21.
Obligement.
May I please, your lordship? Here, my lord, it's a mistake from my office that the requisites have not been filed. It is seen in the.
It's all right. So we permit you to raise all pleas, permitting to raise all the pleas before the trial court. The petition is disposed of. Interim orders vacated.
Specialist item 22.
None appears, dismissal not possible.
Lordship, item number 22, with your lordship permission, we are permitted to withdraw, your lordship.
Withdraw. Dismisses withdraw. All right.
Specialist item number 23. Item 23.
None appears, dismissal not possible. All matters.
Specialist item number 24.
My lord, may kindly pass over.
All right.
Specialist item number 25.
None appears, dismissal not possible.
Specialist item number 26.
None appears. Dismissed in office.
Specialist item 27.
None appears. Dismissed in office.
Specialist item 28.
Your lordship should refer a pass over. All right, pass.
Item 29.
Dismissed in office.
Specialist item 30.
Lordship, I'm praying for a pass over.
Pass. Specialist item 31.
None appears. Dismissed in office.
Specialist item 32.
Permitted to withdraw. Dismissed as withdraw.
Specialist item 33.
None appears. Dismissed in office.
Specialist item 34.
None appears. Dismissed in office.
Item 35. May I please, your lordship. My lord, this case arises out of a complaint petition filed by the opposite party number 2, my lord. My lord, the complaint case as it is made out, my lord, that the complainant and other two brothers, my lord, 3 sons were there of the original owner, the common ancestor. My lord, one of the brother has filed the complaint petition. One of the brother has died, and the other brother, my lord, it is alleged that he has sold some property, my lord, which was entrusted to him by the other family members, my lord. My lord, now the accused persons are the family, the wife, son, and son-in-law. They are the accused persons here, my lord. Your lordship will find, my lord, in the complaint petition, the magistrate refused to take cognizance on the basis of the allegations, my lord. Now, my lord, against that, the complainant went in revision. In the revision, that order has been set aside, directing the court below to reconsider the matter, my lord, for the purpose of taking cognizance. Against that order, I am before your lordship, and it was admitted in the year 2014. Now we are 8 years past, my lord. There is stay of further proceeding in the case, my lord. And my lord, I do not understand, my lord. Your lordship may kindly come to the complaint petition allegation.
Who is appearing for the other side?
Annexure 1.
Have they been served?
Yeah, somebody is appearing probably. I do not know whether he is there or not.
It's A.K. Nayak.
Yes, but he is not appearing probably. Your lordship may kindly come to paste.
Pass it over, sir. Let him come.
Item number 36.
None appears. Dismissed in office.
Item 37. 37.
May I please, lordship. My lord, the petitioners, after this honorable court, to questioning the criminal proceeding on the ground of compromise. Where is it? Petitioner number 1 is the husband, and opposite party number 2 is the wife, my lord. In the meantime, they resolved their dispute, my lord. Affidavit is at page 4, my lord. Annexure 4, my lord. The affidavit of the wife. No, the affidavit is by joint affidavit, my lord. A joint affidavit has been filed with the parties stating that they have settled their disputes. This is not disputed by counsel of the state. That view of the matter. GR case number 217 of 2013, arising out of Champua case number 90 of 2013, pending the court of the learned SDJM Champua, and all orders and proceedings consequent thereto are hereby quashed. The petition is disposed. Obliged.
Specialist item 38.
May it please your lordship. In the mirrors, this is a case filed by the wife against the husband. But in the meantime, I have sent the order copy, mirrors. There has been a mutual divorce between the parties. If your lordship will kindly turn to
For the opposite party.
Sorry?
I am for the opposite party too. Sir is on VC.
Oh, he's appearing for you.
No, I am for
No, I
opposite
am
party
appearing
too.
for the petitioner.
So you agree that there is a compromise?
Yes, it is a compromise. Thereafter,
I would pray that this matter may be heard along with CRLMC 1077 of 2007. Once for all, it will be disposed of.
We take it on board and dispose it of today itself.
Your Lordship, because there will be a mutual divorce, parties
All
are
right.
living separate and
We
there
take
will
it on
be
board. What is the number?
CRLMC
Your Lordship.
1077 of 2017.
All right. That is by whom?
That is by the petitioner and against the order of cognizance. Here is against the order of
right.
posting of
All right. By special mention that is taken on board. And then both these matters, you say counsel to parties inform the court that the matters have been settled between them and there is a degree of mutual divorce under section 13B of the Hindu Marriage Act. Dated, where is it?
I have given that copy, Millers. Petition copy I have filed today in the court.
29/6/2021.
Dated 29 June 2021. Passed by the Family Judge Cuttack in civil proceeding case number 630 of 2020. In that view of the matter, GR case number. No, PS case number 104 of 2014. Pending in the court of the Bhubaneswar Mahila PS. Corresponding to CT number 1408 of 2014. Pending the court of the SDGM Bhubaneswar. And all orders and proceedings consequent thereto hereby quashed. Both petitions are disposed of in the above terms.
Obliged. Specialist item 39.
My lord, 39, I am on behalf of RK Raut, my lord. My lord, the OP number 3 petitioner wife may already file an affidavit. He will living a happy married life with each other, and we are blessed with a doctor, my lord.
An affidavit of the informant is on record stating that she does not want to proceed further in the case. This is not objected to by.
I don't have a copy of the affidavit.
Give him the paperwork, sir.
Please.
All right. That view of the matter. Cuttack Mahila PS case number 82 of 2011 corresponding to GR number 1258 of 2011 pending the court of the Assistant Sessions Judge bracket Special Track Court Cuttack in ST number 451 of 2013 and all proceedings consequent thereto hereby quashed. The petition is disposed of.
Specialist item 40. May I please? In the meantime, matter has already been compromised. Offense under section 498/34.
We permit you to raise all, please, sir. Permitting the petitioner to raise all, please.
Opposite party has already appeared and filed his affidavit.
Where is that?
Flag B, my lord.
Same order as the earlier one then. The opposite party number 2 has filed an affidavit stating that they've settled their disputes and doesn't want to proceed further in the case. In that view of the matter, PS case number 53 of 2010, Bada Bazaar PS case number, corresponding to GR case number 421 of 2010, pending the file of the SDGM Berhampur, and all proceedings consequent thereto hereby quashed.
Item 41.
None appears dismissed or not.
Item number 42.
Pardon, my lord. My lord, item number 42, trial completed, permitted to withdraw.
All right. Counsel of the petitioner seeks leave to withdraw the present petition. Dismisses withdraw.
I am appearing for the informant.
All right.
Specialist item 43.
None appears dismissed or not.
Specialist item 44.
Same order. 45 also same order.
45.
Same order.
Item 46.
None appears. Same order.
Item number 47.
Please, Your Lordship. The proceeding initiated under Annex 3. The de novo proceeding under Domestic Violence Act in the 2000 is under challenge. Under Annexure 1, the 1991, the DB proceeding was initiated. That was ended with a compromise under Annexure 2, and by virtue of the order of the learned court below, Lordship may grants the orders. There, all the amounts whatever in the decree amount.
No, but the DV case was registered in 2013.
No, initially in 1991, Annexure 1, DV case initiated.
No, Annexure 3 is
Second DV case initiated.
after the compromise.
After compromise. That is under challenge, madam. The second DV is not maintainable in view of the first DV was ended with decree.
So what? Maybe there's violence after you went back.
No, because there is no averment. He the 1990 he was kept separate from me, living separately. There is no relation. 1985 is the marriage. 1990.
Let the trial court look at it, sir. Permitting the petitioner to raise all pleas.
Because in the meantime, you also CP proceeding initiated. In the averment, it has
say the absence of the other side, we can't decide it.
Notice issued, they have appeared but did not participate. That is
anyway. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of.
Specialist item 48.
I am appearing on behalf of the opposite party. No, sir. There's a stay in the matter.
Yes.
This is a proceeding on posting.
So you have to speak into the mic.
This case has been filed in challenging the proceeding under section 138 of the NI Act. Your Lordship will see page 9 of the brief, that is the complaint petition. Page 9. A subparagraph is there, page on resignation. In that paragraph, your Lordship will see the check numbers and details respectively on the checks drawn on the said company's current account number.
So all that will be examined by the trial court, sir. Unless there's a settlement between the parties, I'm not inclined to interfere.
Cognizance has been taken, your Lordship will permit me.
Yes, permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right. Both matters. Right.
Specialist item 49.
Both the cases.
Yes, please.
Item 49.
None appears this is not possible.
Specialist item 50. Lordship, on behalf of Mr. Pal, permitted to withdraw with a liberty to file a fresh application.
Liberty to file a fresh application if the cause of action survives.
Specialist item 51. May I please your Lordship? I pray for questioning of the affair manner. Informant has lodged affair on dated 27/2027. After 3 days, he has filed affidavit annexure to mechanism.
What's the offense?
Well, all the offences are available except 506. After charge, all the offences are available.
So there's any affidavit of the victim?
Affidavit filed by the informant manner.
Where is that?
Annexure 2. Yes, he does not want to proceed the matter manner. He already get his claim manner.
2007 affidavit.
Annexure 12, page 12, annexure 2 manner. Make any same.
What's the date? What is the date of that affidavit?
Manner 23 July 2027. 2007.
2007.
Well,
the file is in 15, sir.
Yes. I have filed in CRLM 2015 in the year 15.
After 8 years.
Question of the
you release an affidavit after your filing, not before.
That affidavit has been shown before notary public. Compromise.
Committee to petitioner to raise all pleas before the trial court, the petition is disposed of. All right.
Specialist item 52, obliged.
Memos taken on record, dismissed as withdrawn. Interim order.
Specialist item 53.
No instruction, Lordship.
No instruction to dismiss an order. Same, both the matters. Yes.
Specialist item 54.
Please, Lordship. Here is it. I have for extension of stay order, my lord. Stay order dated 10/3/2014, my lord.
What is the matter about?
Matter is, my lord, the FECA certificate matter, which was stayed before the Supreme Court variance to 3 stay order, my lord. In my IA, page 9, my lord. Answer 3, page 9. Read on page is number 11. Stay order. In pursuance to the self stay order, Honorable High Court also grant.
What is the offense, sir?
My lord,
420, 468, 471.
Where's the other side? Any compromise? Nothing. Permit you to raise all, please, sir. Permitting the petitioner to raise all, please.
my lord, vacation stay order is my lord. Annexed to 1 is my vacation stay order. In pursuance to the Honorable Supreme Court's order, my lord.
Whatever, sir. You are for whom? For petitioner or respondent?
Petitioner, my lord.
Sorry. We permit you to raise all, please. The appropriate stage. Disposed of. All right.
Specialist item
My
55.
lord, especially in the lower court, in the court below, the proceeding is going on.
It should, sir. You appear there and you make all your pleas there. All right.
My lord, in the salience is pending here. Salience
No
is
longer, sir. You just dispose it of. Right.
Item 55.
May I please? Therefore, petitioner challenges the criminal proceeding initiated against him, my lord, under section 363, 366A and 506 of the IPC, my lord. Before my lord filing of this criminal case, we are blessed with a child, my lord, leading a happy conjugal life. And also,
you say that all through the trial court. Either you bring an affidavit here or you say all this to the.
Well, he has already appeared. Opposite partner of 2 has already appeared. His
No affidavit. No affidavit.
No affidavit has been filed.
He is not appearing, but in the cause list, his name is there. What next?
It's all right. You can appear in the trial court and say that. All right. Permitting the petitioner to raise all the pleas in the trial court at the appropriate stage. Petition is disposed. Right.
Item 56.
None appears to dismiss not.
57.
May I please, lords? The entire criminal proceeding, as well as the order of cognizance that is on challenge, the petitioner is a public servant, was working as an assistant engineer in Bisra block, and his work was to supervise the construction work of the block and different GPLs, Gram Panchayat. While the matter stood thus, on 2/6/2014 at 3:30 PM, some sarpanch of that block, they gathered together and assaulted me. As a result of which I filed FIR against them annexed to. The lordship kindly glance the annex the FIR, the contents of the FIR at 24.
Who's the other side?
Other side is some KK Jena and associates, they are appearing.
We pass it over, sir. In their absence, we won't pass it out. Pass over.
Specialist item 58.
None appears.
Well, petition the wife pillar and the opinion to the husband pillar. The dispute between both the husband and wife pillar. The 490 case is pending against the husband, appeal number 2 pillar. And the husband has filed the FIR against the petitioner, the 307, 326 pillar. The notice has gone to appeal number 2 pillar.
Nobody
is appearing.
It's a compromise. I'm not inclined to.
Now the husband is dead, Miller. Now she expired.
Then all the more convenient for you, sir. You just have to go back there and tell them that.
Now the question of the FIR.
Raise all the pleas urged here, the appropriate stage in the trial court, the petition is disposed.
Give me liberty, I'm going to my point. There are criminal charge.
You've given you liberty. Right.
Specialist item 59.
May please, my lord. Lordship, in this case, the petitioner is the husband and the opposite party is the wife of the petitioner. The
Yes.
allegation against the petitioner is that he had kidnapped the wife and their 2 kids along with some cash. Now it has been learned as per instructions of Lordship, they are living together.
You have to file an
Lordship may grant me 1 week's time to file the joint
All right.
affidavit.
Counsel for the petitioner seeks and is granted 1 week's time to file the affidavit of the wife. List on 2nd September.
Obliged.
Specialist item 60.
Yeah, please, after frame of charge, my lord. Arising prior after term of charge, my lord, and quite below.
All right. Permitting the petitioner to raise all pleas at the appropriate stage of the trial court. The petition is disposed of. All right.
Item 61, the matter becomes infructuous, my lord.
Infructuous, disposed of all the matters, connected matters.
61.
61. All right.
Item 62,
May I please, your lordship? The brief has been transferred.
Brief has been transferred.
Mr. Pal name may be deleted.
All right. Dismissed for non-possible. In reward is okay.
specialist item 63.
63, I am the petitioner, my lord, I am in BC.
Yes.
Lord, the petitioner are running a school which is a charitable institution for tribal students, my lord, giving them residential school, my lord.
What's the offense, sir?
My lord, I have come against the initiation of a proceeding under 144, 145 and 146 before the sub-collector on the ground that it is purely a civil dispute. Anyway, they filed a petition in 144, 145, 156 in the year 2015, my lord. In the meantime, 7 years has elapsed, and your lordship will see annexure 6, my lord. That is, of course, in ODM, my lord. I am sorry, my lord, this matter suddenly came up, therefore I couldn't give a translated copy where in pursuance of the order of the sub-collector, an inspection was conducted by the RI, my lord. And he has written.
So the other side doesn't seem to have been served. Opposite party number 1, has she been served?
Yes, yes, they have appeared, my lord.
Who's appearing for them?
Mr. Baharli, my lord.
We'll pass it over, sir. Pass over.
Probably they have lost interest because if no order has been passed in 2015 under 144, my lord, the apprehension of which cannot be perpetually continued for 7 years.
Then you withdraw this, sir.
Let them come, my lord.
Ah. All right. Pass over.
They will create a problem, my lord.
All right. Pass over. Pass over.
Specialist item 64.
None appears dismissed in opposition.
Item number 65.
No instruction, lordship.
No instructions dismissed.
Specialist item 66.
Not rest. Not rest. Dismisses not rest.
Item 67. May I please, your lordship. Lord, the victim and the accused both have jointly filed this application because they have, there is a allegation by the parents on the basis of which the FIR was lodged under section 363 with other offences, my lord. They both have married and now they have been blessed with 2 children. What I have taken instruction.
He's also appearing. Counsel of the parties confirm that both the petitioner and opposite party number 2, no, number 1.
No, petitioner number 1 and 2. Both are petitioners.
Petitioners 1 and 2. Whom are you appearing for?
I am for the informant. Party number 2.
Counsel to the petitioners as well as opposite party number 2 confirm that both petitioners are married and right now have 2 children. In that view of the matter. GR case number 148 of 2015, corresponding to Kashinagar PS case number 18, dated 31st March 2015, pending in the file of the learned SDJM Parla Committee, and all proceedings consequent thereto are hereby quashed. The petition is disposed.
68, same matter. They are the other family members of the accused, my lord.
Or same.
Specialist item 69.
No instruction, lordship.
No instructions dismissed.
Specialist item 70.
None appears dismissed. Numbers.
Item
Pardon
70.
my sir. Pardon my sir, I am on BC. My sir, the conducting counsel for the petitioner has left for Heavenly Abode on September 2020. Meanwhile, we went through the list yesterday night only and communicated
Permit the petitioner to raise all pleas, sir. This is only a 482. permitting the petitioner to raise all pleas at the appropriate stage in the trial court. Petitioner is disposed.
My lordship, 2 weeks may be granted so that we'll trace out the file and file a new wakalatnama and we'll argue on this matter, my lordship.
No, sir, this is, what is the offense?
My lordship, my counsel for the petitioner was my father. I joined this profession prior to 1 month to this date, my lordship.
1 minute, so let's see what the matter is. Let us see what the matter is about. This is Excise Act offense.
We haven't traced out the file at all, my lordship. My lordship, it may be, I may be pleased to be granted.
All right, at the request of counsel, the petitioner list on 2nd September. All right.
Oblige, my lordship.
Item 71.
None of this is not.
Item 72.
None of this is not.
Item number 73.
Lordship, may I permitted to kindly not press this case.
Not pressed.
Lordship.
All right. Dismissed is not pressed.
Item 74.
None of this.
I am appearing for the opposite pet number 2, my lord.
All right.
Item 75.
Your lordship said briefly password.
What's it name? Passover. All right.
Item 76.
None of this.
Specialist item 77.
Please, my lord.
My lord, your lordship, kindly peruse Annexure 1, your lordship. Annexure 1.
Yes.
I give the petition is a lodge and information to branch manager, your lordship, for missing of some checks. Thereafter, my lord, kindly peruse Annexure 2, next page at page 12. Soon after the information given by the petitioner, is lodged an FIR before the IIC, Nagunpur Police Station, your lordship, for missing of the some checks. My lord. Thereafter, your lordship, the case was initiated for insufficient fund by the opposite party.
What is the offense?
Offense 138, your lordship. Here, your lordship.
So this must be a check amount.
No, my lord. My humble submission.
No check amount.
My lord, 2 lakhs. 2 lakhs. The amount is 2 lakhs, your lord. So
when I asked what a check amount, you're saying no.
No, I have not. Sorry, big apology for that. Check amount is 2 lakhs, your lord. So I will not issue a single check. Because
have you settled the matter or something? No.
I have no instructions regarding.
Unless you settle, so we can't quash it like this.
No, how I will settle, your lord? I have not issued any check.
Then you face a trial. You can't settle that, you have to face a trial. You see, permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of. The interim order is located. All right.
Specialist item 78.
Kindly my appearance will be noted. Oblige.
78.
None appears this is not possible.
79.
None appears this is not possible.
Specialist item 80.
None appears this is not possible.
Item 81.
Item 81. The boy and the victim and the accused married in the meantime having 2 children. Your lordship last occasion directed to produce the 164 statement of the victim. She categorically stated that she married to the petitioner number 1. And my lord, your lordship also kindly see Annexure 4, that is the marriage certificate.
All right. The statement of the victim under section 164 CRPC stating that she is happily living with her husband and husband, that is the petitioner and in-laws, is placed on record. This is not objected to by counsel of the state. And that we have to matter. Anandapur PS case number 88 of 2013, corresponding to GR case number 57 of 2013, pending the court of the SDGM Anandapur, and all proceedings consequent thereto are hereby quashed.
Item 82.
Lord, this case will be covered by your lordship's judgment, but for that I need to file some documents because in the meantime he has been the inquiry officer has exonerated him from all the charges. So basing on that, your lordship had delivered a judgment, and that judgment that is in Dr. Minaketan Pani versus State of Orissa. That judgment to that for that means I need to file some documents so that your lordship.
All right, Mr. Manoj Mishra stated he needs time to file some documents. Permitting him to do so list on 9 September. Sir.
Interim order may continue. My lord.
Interim order to continue.
Specialist item 83.
I'm for the informant.
All right.
And I am praying for questioning the order dated.
Paper next to lordship. I am for the petitioner lordship.
Questioning the order dated only 9 August 2015.
9th August
2015.
There's no such order, sir. Which matter are you appealing?
It is, my lord, kindly gone through annexed time.
What is the number of the case, sir? Please read. What is the number of the case?
116. 4081 of 15.
There is no such order of August. Which order are you talking about?
Lower court order. On the next subject.
You are for the informant.
Yes, ma'am.
Is there a compromise?
I have no instruction.
Who's for the petitioner? Mr. Sahu.
I am for the petitioner due to personal difficulty of Mr. Nanda. Kindly taken up next to lordship.
What's the matter about, sir? 138. No, 294-506.
I'm not filed, so
Permitting the petition to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. Interim order. Yes.
Specialist item
next to lordship.
84. May I please, lordship?
Yes.
My lord, can I have a glance to the 164 statement of the victim? My lord, I have already supplied the copy to the London State Council. My lord, the petitioner and victim both are major and they have married. It is clearly stated, my lord, that she has
You've
married.
seen this, Mr. Naik? Yes,
my lords. It's a proper one, sir. The only point probably that my lord will need to consider is at the time she made the statement, she was a minor. Now she is an age.
Or leading the statement of the victim girl under section 164 CRPC. No, it says 19 years when she made the statement.
Actually,
it says 19 years.
No, the instructions that are with me say that the statement has been recorded under 164 CRPC by the Honorable Resident Child Children's statement. The victim girl expressed her age as 19 years, but as per her school admission register age is 15 years.
All right. Counsel the statement of the victim under section 164 CRPC, stating that she is happily married the petitioner.
And blessed with child.
It is added that they now have a child. In that view of the matter, let's take the prayer clause. All proceedings consequent thereto here a clause.
Probably. Specialist item 85. 85.
Lordship, no instruction.
No instructions dismissed for not possible.
Item 86.
May I please? Challenging the order of provisions, my lord. What happened in this case, my lord, the petitioner is the son-in-law, my lord, petitioner 1, and is the mother of the petition number 1, opposite party number 2. The OP2 is, my lord, mother-in-law of the petitioner number 1. Man. After the death of their daughter, my lord, they came to our house and asked for the return the dowry item, madam. And when we did not return, my lord, they filed a complaint case, which is registered as under section 406.
Sir, unless it's a compromise, we're not going to interfere.
Yes, ma'am. Your lordship may directly, I will raise all.
Permitting the petitioners, permitting the petitioners to raise all pleas raised in the present petition, the appropriate stage.
Right.
The petition is disposed of. All right.
Specialist item 87.
None appears. This is not possible.
Item 88.
My lord, on behalf of HN Mahapatra, file is misplaced. I pray for next week so that I will reconstruct the file.
All right. At the request of counsel, the petitioner list on second.
Specialist item 89.
None appears. This is not possible.
Specialist item 90.
None appears. This is not possible.
91.
My lords, I may be permitted to withdraw the matter, my lords.
Counsel, the petitioner seeks leave to withdraw. Dismisses withdraw.
Item 92.
My lord, no instruction, my lord.
No instructions dismissed.
93.
None appears. This is not possible.
Item 94.
None appears. This is not possible. Both matters.
Item number 95.
May I please your lordship, on behalf of Mr. Agada, kindly raise this issue, all the points before London court.
All right. Permitting the petitioner to raise all the pleas before the appropriate court, before the appropriate stage.
Item number 96.
My lord, 96, the lower court case already closed, my lord, in the meantime.
Okay. Counsel, the petitioner states the petitioner is rendered infractuous, disposed of as such. Interim order.
97.
My lord, like 97 on behalf of PK Mishra, my lord, personal difficulty, mother admitted in hospital.
All
So, my
right.
lord,
List on second. All right. At the request of counsel, the petitioner list on second.
Item 98.
None appears. This is an opposition.
99.
May I please your lordship. Here, my lord, the petitioners challenge the criminal proceeding my lord initiated against them in PS case number 484 of 2015. During pendency of the petition, my lord, petitioner number 1 has expired and 2, 3, this cause of action still survives in favor of petitioner.
This is a 302 matter, sir.
That's a kind of a glance. I am challenging this application law. In 2003, my lord, this case is instituted and the final form was filed by Annexure 2, my lord, that this is a false case. Again in 2015, my lord, when these petitioners were arrested in connection with other case, they were in custody. At that point of time, the petitioner again filed a FIR, the informant, and that was taken, my lord. And
the 302 should not have interfered at all, sir. I don't know how we interfere like this. The 302.
That's the
302 case, sir.
302, my lord, the police has said,
got it stalled for 6 years now.
No, this is a case of clear suicidal case. Postmortem report.
Whatever investigation has to carry on.
No, the police had filed the final formula.
Then why are you worried?
Again, they filed after 12 years this FIR.
It's all right. It's all right.
When we are in custody, after 12 years, again they filed. And the petitioner number 2 has filed the FIR in 2003, my lord, stating that the deceased was working in his office and he has made suicide, my lord. Thereafter, the police taken up the case and in 2005 filed the final form saying that this is a case of suicidal. And the postmortem report also annexed 2, that is clear, my lord.
You can show it to the trial court, sir.
This is a case of suicidal hanging.
All right. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. Interim order is vacated.
Petitioner 1 has expired, my lord.
That's all right, sir. That doesn't matter.
Specialist item 100.
So shall I stay in this case because stay is there because other 2 cases. The police,
sir, you can say that to the trial court. All right.
My lord, filed the present application to pass to enter the criminal proceeding on the ground of compromise, my lord. Petitioner, my lord, married to opposite party number 2, my lord, in the meantime, my
You
lord.
are appearing for opposite party number 2. Or counsel appearing for opposite party number 2 agrees that the parties have married and are living happily together. In that view of the matter. GR case number 700 2015 arising out of Ghasipura PS case number 252 of 2015 pending the court of the SDJM another and all proceedings consequent thereto are hereby quashed. All right. Pass over.
Specialist passed over matter. Item number 24.
20.
24.
My Lord, I am for the petitioner case of elopement. My Lord, annexure 2 is the 164 statement of the victim, the lady. If you, I will seek your lordship 7 days time to file a fresh affidavit by both the parent, the father and the.
All right.
victim.
Once the petitioner prays and is granted 1 week's time to file fresh affidavits of the girl and the father. 9th September.
No.
Passed over matter item 28.
Challenging the order of cognizance manner. Challenging the order of cognizance manner.
What's the offense, sir?
Offense manner under section 294, 323, 506, 379 and 34 IPC.
We permit you to raise all pleas, sir. Permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
Passed over matter item 30.
Wait, please, my lordship. Lordship, I am the house owner, property owner, and the opposite party is the tenant who was staying there.
Yes.
He filed an FIR under section 448 and 506 for house trespass and criminal intimidation, your lordship, which suffered a final report, which is at page 17, that it was a false case. After that, he filed a protest petition and only cognizance for 506 has been taken, your lordship. Lordship, I am a 65-year-old man who was the owner of the house. Even if the allegations are seen from the face of it, from whatever has been alleged.
So he is not here. The difficulty is he is not here. The informant.
Yes, your lordship.
He may not turn up in the trial court at all, sir. You better raise it there. Permitting the petitioner to raise all pleas in the trial court.
Lordship, I am a 65-year-old man. This is only.
So all right. You are not going to be physically present. You are going to send a lawyer. And the petition is disposed of. What is located. Yes.
Item 35.
The opposite party was voted, my lord. Here is a case your lordship will find, my lord. Page 13, your lordship may kindly come to page 13.
What's the offense?
Offense is 406. Alleged offense is 406, my lord. My lord, the magistrate refused to take cognizance. My lord, thereafter matter was carried in revision before the revisional court, my lord. In the revision application, my lord, the court below has, my lord, while setting aside the order, has directed reconsideration of the cognizance.
How is it prejudicial to you? It's a reconsideration.
No, reconsideration, but your lordship will find, my lord, your lordship will find page 13, lordship may kindly come to page 13.
Has opposite party number 2 been served?
Yes, yes.
One AK Nayak was supposed
to be. Somebody is appearing, but he is not there, my lord. My lord, page 13, lordship will find, my lord. There was a joint family property, my lord. My lord, 3 brothers were there, my lord. Out of 3 brothers, my lord, 1 brother has died. And the petitioners are the descendants of the deceased brother, my lord. Now, the allegation
is going on.
No, that is exactly what I am saying, my lord. A civil suit is going on, and what for this complaint petition has been filed, and why the other persons, your lordship will find, my lord, the entire allegation, even if accepting for a moment, my lord, the allegation against accused number 1 and accused number 6, my lord. What is the necessity of adding the other accused persons? I do not understand, my lord, on the face of the complaint petition. That is absolutely no allegation against the other accused persons. And this is a case, my lord, which is civil in nature, and the suit is filed. That can be decided there, my lord. And what is the necessity of filing this complaint petition? And the revisional court has set aside the order, and he protested, and the allegation is accused number 1 sold. So, my lord, if that is accepted, my lord, then it is a civil dispute.
Complaint is too hard. Only that is the.
He is not out of a complaint petition.
I know.
In absence of the complainant, I think did not pass.
And it is a matter of 2014.
Complainant is what, a brother?
Brother, my lord. Complainant is the brother, my lord.
Complainant is already 70 at the time of filing of the presentation.
Yes, my lord. Might have, my lord, I do not know what
you better find out
has happened to him.
The petitioner wants to find out the current status of opposite party number 2. Add his request list on 9th September.
May you come to make item number 34, I have just put to
34.
34. Now, can they only in order to complete the trial within a period of 6 months to 3 months, whatever the trial is pending since 2007, my lord.
All right, permitting the petitioner to raise all
Make
pleas
it
at the
time
appropriate
bound.
stage with the trial court. The petition is disposed of. It will be open to the petitioner to request the trial court to conclude the proceedings expeditiously and preferably within a period of 6 months from the date of production of a copy of the order. The petition is disposed of in the above terms.
Item 57.
May it please, lordship. That the petitioner is a public servant and he is working by the time that cause of action arose. He is working at the assistant engineer in Bistra block. And his work, the petitioner work is to sanction and also supervise the CC work of the villages. Some village, the sarpanch of the some villages, they compelled him to execute that work as per their instruction. When I did not do, they assaulted me, as a result of which I lodged a FIR against them, Annexure 1. The contents of the application, that is Annexure 1 at page 24.
What has happened to this FIR?
Prayer I have,
No, what has happened to it? Was it investigated? What happened?
that application, so far my FIR is concerned, there is no investigation. Subsequently, they filed a counter FIR against me on 4/6 after 2 days. That was Annexure 2, your lordship, and they set up a lady sarpanch taking advantage of section 354. And allegation was there on 323 and 354, your lordship. A police investigated in that matter and submitted the final form. Your lordship, kindly the final form, both police said that it is a false case. Page 36. Page 36, your lordship, kindly glance, Annexure 4. The final form police submitted. And thereafter, one complaint case was filed against me that I have outraged her modesty or criminal assault, anything. And that law and magistrate had taken cognizance and no sanction has been obtained. 197, your lordship.
What's your age now?
Millet.
4. All right.
An entire allegation, your lordship, kindly glance.
Let us consider the trial court. And here the complainant is also absent.
Sorry,
Complainant is not present.
I know.
All these matters.
No, complaining to serve, there's a lawyer appearing on her behalf.
Yes, ma'am. None is.
One KK Jena.
Yes, madam. And the personal, satisfy the personal gross, the complaint case was filed.
We pass it over only for him. He's not appearing.
Yes, boss. I leave to lordship's judicial consent.
Despite a passover, Mr. Jena, learned counsel for opposite party number 2 is not appearing. Interim order to continue in the interest of justice list on 30th September.
Published.
Pastor matter, item number 63.
Lord, you lordship may look at the complaint petition, Lord, page 11.
Yes.
Passed it over because the other side is not there, he is still not there.
So here again, because the counsel for the opposite party is not appearing, we'll have to adjourn it again. Despite a passover, none appears for opposite party number 1 in the interest of justice list on 23rd September. Interim order to continue. All right.
Pastor matter, item number 75. 75.
Item 75, my lord, only kindly taken on next week, my lord, I pray, my lord. And it's a file not.
Despite what you have for the petitioner,
My lord.
why are you asking adjournment?
My lord, file missing, my lord.
Or at the request of counsel, the petitioner list on 30th September.
Permitted to mention your lordship. In item 8, your lordship was appointed arbitrator, my lord. Arbitration ARBP number 31 of 2022. And this case you file also memo that I personally the opposite party was served the notice. Lordship, the tracking Sorry, lots of the noting is the tracking report is sufficient, but in respect of also the petitioner also served the section 8 petition with the opposite party has knowledge that the matter is posted today. That memo I kept, but I could not file my lord on instructions.
All right.
All right, oblige also.
May it please. My lord, the petitioner is appellant is now custody for more than 10 years. And charge was framed under section 498, 302, 304B, 34 of the IPC. But the land court below has, my lord, discharged me from 498A and 304B IPC as petitioner is not the legally wife, my lord. Your lordship may kindly glance to page 22, judgment page 18, my lord. Second para. May I read?
Yes, please.
As Kumudini was earlier married to Akshay Digal and became the mother of through him in the absence of any evidence on record that after being legally separated, divorced from the said Akshay Digal, deceased Kumudini remain with accused Karna as his de facto or dummy wife. To my consideration, Kumudini legally cannot be treated as the wife of accused of Karna to bring him within the ambit purview of offence under section 498 304 IPC. Hence, on the basis of procedural record, Karna legally cannot be tried faster with the charge under section 498 304B. Subsequently, my lord, so far as 302 is concerned, my lord, it is based on circumstances evidence. And
Justice Sahu, he spent 10 years.
Let him go.
Perfect. The appellant has been convicted. Although the appellant was charged with the offences under section 498A, 304B and section 302 IPC, has been convicted only under section 302 IPC, has been acquitted of the other offences. The case is based on circumstantial evidence. The admitted position is the appellant to spend more than 10 years in custody. It is unlikely that the appeal in its usual turn will be taken up for hearing in the immediate future. Accordingly, the court directs that the appellant be enlarged on bail, subject to the satisfaction of the trial court. The paper books nevertheless be prepared and the matter be placed in the list of regular hearing soon thereafter. Right. So Samir Mishra has to come.
Supplementary list for admission item number 1.
I may please your lordship.
Yes,
My
yes.
lord. Yes, my lord. Yes, in this case, my lord, there is a delay of 42 days in filing the restoration petition because in the cause list, it escaped our notice that matter is listed, my lord. Therefore,
You're in some other matter, sir. You're in some other matter.
This item number 1, RGWPET 10 of 2022.
This matter,
Just now,
I have served an
I had given an affidavit. I tried to go through, but the difficulty is, my lord, I was in fact before my lord Justice Mahapatra in civil bench. I just crossed in because my matter was about to be taken up.
All right, all right.
Well, this I have to go through and assist.
All right. An affidavit has been filed by Gail, which is handed over in court. A copy thereof has been served on Mr. Samir Mishra, then counsel the review petitioner, who seeks time to examine it and make submissions. We'll have it 2 weeks thereafter.
Because your lordship wanted whether they can see it. I think possibly they have indicated they cannot, but I'll find. I have
multiple dimensions were there.
9 September. 9 September.
My.
All right. All right. Right.